Hi, this is Kip from Malek. If I briefly talked about overpayment and fraud in a prior video, and then my brother Doug Malek commented about how he had a case, and it's Ransom versus IC. So I'm going to talk about that case. It's a 10th district appellate case. I'll put the case in the comments, and you can download the case and read it yourself. But essentially, the case involves a situation where the Industrial Commission found both overpayment and fraud. Doug filed an appeal to the 10th district. There's still an overpayment, but there's no fraud. And the factual situation is such. This individual had filed for temporary total disability comp at the SHO. Well, he had a hearing at the SHO on for temporary total disability on June 26, 2007. It was denied. Comp was denied. And then so this individual, he's like, well, I got to make money. I got to be able to pay my bills. I got to be able to eat. So he ends up getting a job July 15th, 2007. He works till December 9th, 2007. In the meantime, whilst he's working, we're doing our job, and we file for a site condition, and then we file for a comp starting from when the site condition was, when he was examined for the site condition up to and continuing to the date of the hearing. And what ended up happening is the site condition wasn't allowed until November 6, 2007. He ends up, again, if you're following along, again, July 15th, 2007 to December 9th, 2007, he was working. So the site condition gets allowed November 6, 2007. He ends up having this hearing regarding temporary total disability, and in February 22nd, 2008, and the Industrial Commission awards back period of comp from 2006 to the date of the hearing to continue. So let's jump forward in time because we're talking about fraud. And so if you're following along, you should know as an injured worker, if you are one, or if you've ever had a workers' comp claim, that you can't work and get temporary total disability at the same time. You either work and get your wages, and there's other forms of comp you might be able to request, or you're not working and you're getting temporary total. You don't get both. If you get both, at the least, least case, you're going to have an overpayment. Worst case, you're going to have an overpayment and criminal fraud. So anyways, so the Industrial Commission and the BWC and the Industrial Commission are going to find this stuff because they'll do searches based upon your Social Security number, and it'll, if any tax has been paid, reported on that social, it's gonna flag them, and they're gonna start looking. So they did, and they did this investigation. And so at the DHO of April 13th, 2010, the SHO 5/19/2010, they found fraud. So, and they found fraud because he had done two things. One, he had signed a C-84 in November 27th, 2007, saying he wasn't working, when in fact he was. So remember, C-84, if you had been working even a closed period, you have to indicate that in C-84. He didn't do that for whatever reason. And then he was examined by a few different doctors. So the first doctor was Dr. Ryan in July 2007. And he indicated to this Dr. Ryan that the date he last worked was in 2005. He was examined by a Dr. Cleary, and I assume that was in conjunction with a psych condition possibly. And so that was September 25th, 2007. And again, he told Dr. Cleary, hey, the last time I worked was 2005. And then he was examined by a Dr. Tosi on June 23rd, 2008. And again, he told that doctor that the last time he worked was in 2005. And his treating psych doctor, Dr. Howard, on November 27th, 2007, he had reported to Dr. Howard that he wasn't working either. So the Industrial Commission said, hey, you got fraud, there's fraud, and there's an overpayment. Doug appeals it to the 10th District, and the 10th District found that there was no fraud. In order to prove fraud, you have to prove 6 elements. I put the elements in the comments. I'm not going to go through all 6 elements, but the first element of fraud is you make a representation, or where there is a duty to disclose, and you conceal some facts. So you're supposed to explain something, you're supposed to alert somebody of something, and you conceal this fact. And so the IC is saying he had a duty to disclose to the Industrial Commission, the BWC, hey, I was working over this closed period from July to December of 2007. Because he didn't do that, they're saying that he committed fraud. The magistrate basically said, no, he didn't commit. There's no duty to disclose at the time that he allegedly committed fraud because he wasn't receiving compensation at the time. Remember, July through December of 2007, he wasn't receiving temporary total disability, so he wasn't receiving anything. So if you're not receiving temporary total disability, you don't have a duty to disclose, I'm not receiving temporary total disability. And then the other thing is, DIC, they claim that he and that they had warned him, or he was supposed to disclose, but again, the magistrate said no, and then he did not sign any warrants warning that he could not work while he's actually working. I don't know what a warrant is in this context, but assuming it's some kind of warning, hey, you can't work and over the closed period of time. So maybe if they had sent something to him back in July saying, if you're getting temporary total disability, you can't work, you understand that, and he had signed and dated that, then that would have been some evidence that he was aware that he can't work and receive comp at the same time. She said there was only one C-84 that he signed, and that would have been 11/27/2007. And again, at that time, he really didn't have a duty to disclose. Now, apparently he didn't indicate that he was working, but he wasn't receiving comp at that time. So I guess her theory is he didn't have to disclose anything. So, and then he wasn't put on notice that he could not work while receiving temporary total disability until February 28th, 2008 via BWC letter. And then there was an electronic bank transaction letter dated March 4th, 2008 that said, hey, you can't get temporary total and work at the same time. Now, the thing is, at the time that he was granted comp, so he was granted comp in February of 22nd, 2008. At that time, he wasn't working, remember? So it was July 2007 to December of 2007. But in February of 2008, he wasn't working. So it seems like there's a lot of elements that, and I think Doug probably did a really good job arguing his points. I think one magistrate might find that there's no fraud. I think if you give the same facts to another magistrate, they might find that there's fraud. And that's kind of that human factor, that decision factor, that whoever's hearing the issues. Because when you look at it, you're like, well, he misrepresented to his, like 3 or 4 doctors. He didn't sign on the C-84 that he was, that he was working over this period of time. But this magistrate found that he did not commit fraud. And again, there's 6 elements. They failed to, if you don't get all 6 elements, it's like with the criminal thing, if you have to prove the elements of your case. It's like with, that's what they're going to have to do against, anytime you go to a criminal case, the state or whatever, they have to prove the facts, the elements of the case. So the magistrate said, hey, you didn't even prove the first element, so I don't have to go through the rest of the things. And for that reason, she found there was no fraud anyways. So no fraud, but there is an overpayment. So he had an overpayment for that July to December period. So that's the Ransom versus IC case. I will put, again, the case in the claim, the case in the comment section. You can download and read yourself. But this is a case where Doug did some good lawyering and got a beneficial result, or at least fixed a problem that was created by the clients, or at least by the facts in the situation. So good result. But as always, if you're working, you don't get temporary total. Okay, just don't do that. And anyways, if you have any questions, comments, etc., you could leave them in the comments, or you could email me. As always, when I end these things, I always recommend that if you have a workers' comp case, these things are too complicated, you 100% absolutely need to get an attorney to get involved in your case. If you don't have an attorney, you're gonna run into problems. So you could even run into problems when you're represented, frankly. So, in fact, be that as it may, you could either call us or do a Google search, ask your friends, family, coworkers for reference for a workers' comp attorney, but run your situation by them, and maybe they could say, hey, you need to do this, you need to do that, etc. So thanks for listening to this. Hopefully it was useful to you, and it explores further this overpayment fraud area of workers' comp law. Thank you.